Hello, doctors. I'm Dr. Chris Rapoff of EZ QME Continuing Education, and welcome to this week's Case Law Update. Today's case will be a review of some very important labor code sections, specifically Section 5412, and the labor code that defines the date of injury in a cumulative trauma industrial injury case. Here we have a defendant raising an issue in the Lomeli versus County of Los Angeles. And was the defendant successful in their attempt to overturn a prior workers' compensation judge's ruling stating that the statute of limitations had run out in this case? Well, let's take a look. Very interesting. Today's case involves an appeals judge granting the defendant a petition for reconsideration of a prior ruling by a workers' compensation judge in 2022. And in that case, they found that an applicant had actually sustained an industrial injury, in this case, Mr. Lomeli. Now, Mr. Lomeli was previously employed as a fire captain during a cumulative period ending in March of 2016, 6 years prior. And he is saying that he sustained industrial injury, and it was confirmed by a QME in the form of asthma causing a permanent disability of 25%. This is where the defense says they don't think so. So originally, the workers' compensation judge found that the applicant, in this case Mr. Lomeli, was not barred by the statute of limitations in their filing. If you remember, he was last employed in 2016, and this case comes in 2022. The defense has a different idea. They contend that the judge actually did err in finding that the claim was not barred by the statute of limitations. We're going to get into the actual labor code sections and discuss this a little bit further. Okay, as I mentioned, the statute of limitations are what are at question here. And the statute of limitations, if you're going to run that as a defense, it has to be an affirmative defense, which requires the defendant to prove evidence and not the applicant. So Labor Code Section 5409 states that the statute of limitations is an affirmative defense that operates to bar the remedy and not to extinguish the right of the employee. So under this code, an applicant's claim is actually barred if the application is not timely filed from either 1 year from the date of injury, 1 year from the date of the last indemnity, or 1 year from the last medical benefits. Now, according to Labor Code Section 5405, this date could be the date of the injury, or the last payment of the disability indemnity, or the last date of medical treatment. So in this case, the applicant was not given disability indemnity or medical treatment, so the relevant date is the date of the injury. Now, according to Labor Code Section 5412, the date of an injury in a CT injury case is, quote, that date upon which the employee first suffered disability therefrom and either knew or in the exercise of reasonable diligence should have known that such a disability was caused by his present or prior employment. And we'll get into this as how the applicant was able to assess their condition and discuss how Labor Code 5412, Section 5412, actually came into play here. Again, let's take a look at the Labor Code sections in its issue. And in this case, it is the definition of disability, according to the Labor Code Section 5412. And as I mentioned, it states that the impairment of bodily functions must result in an impairment of earnings capacity in order for it to be considered a disability. Now, the Court of Appeal made it clear that the medical treatment or work restrictions without wage loss do not constitute disability. Okay, so the defendant argued in the case that the applicant should have known that his diagnosis was industrial way back in September of 2016, but failed to explain when the disability first occurred. So that's why they're trying to get this thrown out. Now, here the real question is whether or not the applicant would have known that his injury was work-related had he done a reasonable, diligent investigation. Now think about that. We are supposed to do an investigation as an employee or as a patient. And the applicant first learned of his asthma diagnosis when he was evaluated by a Kaiser doctor in 2016. So there's some history. But the records, there is no indication that the applicant was informed that his injury was work related by the doctor. So in December of 2019, the applicant informed the Kaiser doctor that he had been working with some dust and smoke and specifically worried because of his history of being a firefighter. So the record does not state that the doctor actually told the applicant that the asthma was work related. But from the action of the doctor, as he continued to care for the applicant through the private insurance, they are saying that we can deduce that the doctor did not tell the applicant that the condition was work related. The court found that this interaction with the medical professional constituted a reasonable, diligent investigation to determine if the applicant's asthma was really work related. Now, Mr. Lomeli didn't have that knowledge that his work injury was related to work until August of 2021, 5 years later after he left the company or the county. Okay, so specifically, let's get back to the case. So the defendant files this petition for reconsideration in November of 2022, and he says that the applicant's claim should be barred due to the statute of limitation and that they had knowledge of the workers' compensation rights due to their experience. So in other words, they're saying that they should have known that this was going to be the case and the statute of limitations would have caused this to not be filed or awarded. So the parties appeared in 2022 and some documentary evidence was received. And in 2022, the workers' compensation judge granted the applicant the 25% permanent disability award and found that the claim was not barred by the statute of limitation. The workers' compensation judge also found that the record needed to be developed furthermore for some more medical treatment, and the defendant actually sought relief from that finding as well. Okay, these are important, so we're going to discuss them just briefly. Again, Section 5409 states that the statute of limitations is an affirmative defense that bars remedy but not the right of the employee. So it's the defense that has to prove this. In Section 5412, that's the date of injuries we discussed, and that's the date of disability when the employee knew or in exercise of reasonable diligence should have known that the disability was caused by their present or prior employment. Now, the main question in this case was whether the applicant, Mr. Lomeli, had done a reasonable and diligent investigation to determine if his asthma was work-related. He first learned about the diagnosis in 2016, but the record didn't show that the doctor told the applicant that the condition was actually work-related. Now, let's think about this. For instance, we can look at another case potentially where you have a coal miner who retires. And 5 years later, after retiring, he develops mesothelioma. He goes to the doctor, does not relate that to his coal mining incident, but look at that. 5 years prior, which means the statute of limitation had expired. So then we have an affirmative defense where the defense has to prove differently in Section 5409. So this isn't an isolated case, and you may actually see some of these issues in some of your clients as well when you do an examination for the QME report. So in Mr. Lomeli's case, the court actually found that the interaction with the medical professional at Kaiser constituted a reasonable, diligent investigation. So the defendant didn't meet the burden in the case, and they had to show that the applicant knew that was asking their private doctor was not enough to determine the cause of the asthma. And they had to seek a doctor familiar with workers' compensation. So the defendant is actually saying, well, the applicant didn't put it together, and the doctor put it together, but was considering this to be a private medical case. And, the doctor should have been familiar with, or if he wasn't, Mr. Lomeli should have found a workers' compensation doctor that was familiar with the labor laws. So think about that, how ridiculous that sounds. So the appeals board ruling was, I don't think of any surprise to anyone. The defendant's petition for reconsideration was actually denied, and Mr. Lomeli was awarded his 25% permanent disability due to asthma. Okay, so to summarize, we have the defense attorney here interpreting Labor Code Section 5412 much differently than the applicant attorney did. Why? Well, here Mr. Lomeli's permanent disability award of 25% was upheld, much to the disappointment of the defendant. Let's just keep this as a reminder to all QMEs of the importance of every aspect of the medical legal case, even something that sounds as simple as a date of an industrial injury. And finally, just keep in mind also, we're hearing more and more about something like this as you consider the first responders in the 9/11 cases. So here we have 9/11, which is 12 years ago. We are still seeing cases that are being brought as a workers' compensation issue, and they're being won in court. Well, once again, I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time to join me in this presentation. I hope you enjoyed it, and I do look forward to sharing some other interesting cases again with you real soon. Thank you.